Thank you for joining us today for this briefing on the new proposed rule on DACA and how campuses can engage. My name is Miriam Feldblum, and I'm the Executive Director of the President's Alliance. I want to thank at the outset the co-sponsors for this briefing. They are the Dream.us, which is the nation's largest college access and support program for undocumented students and whose scholarship opportunities are now open for applications. The Penn State Law Center for Immigrants' Rights Clinic, the founder and director of which is Shobha Sivaprasad Wadia. The UCLA Center for Immigration Law and Policy, whose founder and faculty co-director is Hiroshi Motomura, and the law firm Curran Berger and Clute and its partner Dan Berger. Shobha, Hiroshi, and Dan also sit on our legal advisory council, and we're deeply grateful for their leadership, expertise, and dedication, and thrilled they are here with us today. The nonpartisan and nonprofit alliance brings over 500 college and university leaders together on the immigration issues that impact higher education, our students, campuses, and communities. We work to advance common sense and forward-looking immigration policies and practices at the federal, state, and campus levels for undocumented international and refugee students. The purpose of this briefing is to discuss the new proposed DACA rule that was released by the U.S. Citizenship and Immigration Services last week. We welcome the administration's commitment to engage in deliberative rulemaking and in working to defend DACA from legal challenges. Our speakers today will address what the rule means for current DACA recipients, what campuses need to know, how different is it from what exists now, what are the implications, what improvements do we want to see, and how can campuses engage, both to submit comments on the rule and supporting undocumented students and dreamers. We'll end with a Q&A and discussion with all the speakers. We've created a Google folder with a link to the slide deck and other resources that you can find in the chat. We have 5 outstanding speakers today, and you can see their full bios in the chat as well. Starting with a crucial campus voice, Suzanne Hayden Dyer is a DACA recipient, the Dream.us scholar, and my colleague, as she is also a President's Alliance Student Fellow. Suzanne has an associate's degree in criminal justice and is currently completing her bachelor's degree in business administration with a concentration in human resources at Miami-Dade College. Following Suzanne, we'll hear from Shobha, Hiroshi, and Dan, who will delve into the rule. First, Professor Shobha Sivaprasad Wadia, who's a leading immigration expert, will explain the history of deferred action and what we need to know about this rule. Next, Professor Hiroshi Motomura, a nationally renowned immigration legal scholar, will analyze why the proposed rule is structured as it is, including the ability to apply for DACA and work authorization separately. Then Dan Berger, immigration lawyer and external counsel to many campuses, will address what portions of the rule institutions could consider commenting on. Finally, Jose Magana Salgado, Director of Policy and Communications here at the Alliance and a DACA recipient, will introduce the comment guide we've developed for campuses, with input from our legal experts, including those here today and others on the Legal Advisory Council. Jose will also highlight how this rulemaking fits in with the simultaneous efforts to advance some kind of immigration reform for dreamers and others through reconciliation in Congress. We then bring all the speakers together to engage in conversation and Q&A. A touch of housekeeping, please put your questions in the Q&A and we'll work to address questions during the briefing and discussion. This briefing is being recorded and we'll share the recording with all registrants and it'll be posted on our website. Now I'm thrilled to turn this over to Suzanne. Suzanne.
Thank you, Miriam. I've been in the United States since I was 3 years old, and for many years, I did not realize that I was undocumented. It was not until I was in high school where my friends were applying for their first jobs, traveling outside of the country, and later preparing to apply to colleges that I began to understand what my status in this country was. I was not able to participate in these coming-of-age activities that many of my peers could take part in. I realized that being undocumented created limitations. I was not able to apply for jobs, and trying to navigate if or how I would be able to attend college was a difficult journey. I knew this limited the opportunities of what I would be able to do for my future. It was a devastating feeling. It was not until June 2012, when DACA was first announced, that I began to have a sense of hope. I applied for and received DACA for the first time in 2014. I finally began to feel a true sense of relief and a bit of hope for the future. For the first time in my life, I had a social security number and a work permit. I was able to comfortably apply for jobs, and I began to take the next steps into adulthood. For me and other DACA recipients like me, having a work authorization is not only important, but is a necessity for our livelihoods. Being able to work is how many of us provide for ourselves, our families, and at times our extended families. And as a student, it was how I was able to pay for some of my college courses until I received the Dream.US scholarship in 2020. The United States is my home, but living in a constant state of uncertainty can be a daunting task. Fortifying DACA is a necessary step, and it will continue to offer protection to me and the over 700,000 individuals that depend on this program. This is just one step in a continuous journey as we eagerly continue to hope that Congress will soon provide a pathway for legalization and ultimately citizenship. Thank you.
Thank you so much, Suzanne, for sharing your story and your perspectives. Really appreciate it. Now over to Shobha. Shobha.
Thank you, Miriam, and to the President's Alliance for putting this on. I'm honored to be here. And I wanted to start with a background on the law and history of prosecutorial discretion and deferred action in particular. Prosecutorial discretion has been part of the immigration system for as long as it has operated. And it refers to this idea that there are limited resources, and so agencies, in this case, the Department of Homeland Security, has the authority and necessity to choose who it is going to target for removal and who it is going to deprioritize or leave on the back burner. Deferred action is one kind of prosecutorial discretion in immigration, and it has been used over many different administrations under this resource or limited resource theory I just mentioned, but also under a humanitarian dimension. Over and over, we've seen that equities and humanitarian factors have driven who agencies identify for deferred action. So the history of deferred action is vast, and it was once called non-priority status and was published in a pretty technical document called the Operations Instructions, which only became public in 1975 in connection with a lawsuit brought by the lawyer for the former Beatle, John Lennon. That operations instruction for non-priority status and later deferred action listed specific equities: advanced or tender age, residence in the United States, medical conditions, as among the reasons for why a person should be protected through deferred action. More recent documentation has been in the form of memoranda by the Department of Homeland Security. So, for example, a memo was issued to protect the widow and widowers of U.S. citizens through deferred action. Other guidance documents have been used to protect particular survivors of crime and trafficking, or those who are waiting for a visa to become available. And finally, as an example, deferred action has been used to protect students who were affected by Hurricane Katrina, who were unable to have a full course load as required in their student status because of this disaster. There has also been individual acts of prosecutorial discretion and deferred action that have been issued over the years for these humanitarian reasons: tender age, long-term residence, and so on. And here I really want to highlight the strong connection between the history and who has been protected through deferred action and the features of DACA and those who have been granted DACA. There's a real connection and consistency. So for example, in the DACA population, we know that the vast majority, or at least an average, entered the United States at the age of 6. They all have long-term residence in the United States. By virtue of the terms of the policy, every DACA recipient has been in the United States for over a decade. Many also have family ties, as included in the proposed rule. More than 250,000 DACA recipients have at least one U.S. citizen child. There are some pretty significant legal foundations for deferred action, beginning with the Take Care Clause of the U.S. Constitution to the immigration statute, which delegates to the Secretary of Homeland Security the authority and responsibility to make enforcement decisions, as well as the Homeland Security Act, which charges the Secretary of Homeland Security with setting priorities. There are also a number of Supreme Court cases and federal court decisions that authorize and underscore the role of deferred action in immigration cases. Among them, Arizona versus the United States, and most recently, the case of Regents. And finally, there are guidance documents. These are sub-regulatory, non-binding documents, such as that operations instruction and memorandum I just mentioned earlier. I want to highlight the fact that this history and these legal authorities that I just mentioned are really part of the narrative of the proposed rule on DACA. And this narrative is quite important to provide clarity and education to the public, as much as to have on the record the strong and clear legal foundation for policies like DACA. The narrative also is clear in sharing that the proposed rule should not be interpreted as suggesting that the Department of Homeland Security doubts the legality of DACA as a policy. Finally, and I think this is quite important because it has been misunderstood in the public, the agency is quite clear in explaining that Congress's failure to enact legislation for individuals with qualities and equities similar to those who are eligible for DACA does not call into question the statutory authority for deferred action. And this point is really important both to our understanding about the role of executive power and its relationship to legislation and the political discourse which has clouded this legal reality. Deferred action is a temporary reprieve. It is within the scope of executive authority. It is not the same as legal status and the DREAM Act, which, if enacted, would provide a durable status and a solution for those with DACA-like qualities. I want to talk a bit about the history of the regulation governing work authorization, which also enjoys a long history. It was published as a rule in 1981 under the Ronald Reagan administration, and it allows any person who has been granted deferred action to apply for work authorization if they can show economic necessity. And the proposed rule for DACA maintains this content, but proposes to create a separate regulatory provision for DACA-based work authorization specifically. Why that is, my colleague Hiroshi Motomura will explain in a bit. Finally, I want to talk about the interrelationship between lawful presence and deferred action. The proposed rule reiterates that deferred action recipients are considered to be lawfully present. And this is grounded in long-standing rules, including a regulation at 8 CFR 1.3, which considers deferred action recipients as those who qualify for social security benefits. Another way that lawful presence is important is its connection with a legal term of art in immigration called unlawful presence. This, if triggered, has severe immigration consequences, but it has been the case for decades that individuals in a deferred action status do not accrue unlawful presence. And the agency in the proposed rule asks for commentary from the public as to whether lawful presence should continue to be pinned to DACA as it is to other deferred action grants, or whether lawful presence should be decoupled. And hopefully we can use the discussion time to consider why. Thank you.
Thank you, Shoba, for that. And now let's turn to Hiroshi Motomura.
Yes, thank you. So as has been previewed, what I wanted to do was to build on what Suzanne and Shoba have just said, and speak more specifically about the proposed regulation, and in particular, why it's structured the way it is. It may seem mysterious, but I think that it's worth getting into it because it both drives a formal general assessment of it, but it also suggests some of the framing that might be brought to commenting on the proposal. So, the proposed regulation is very cautious. In many ways, it's defensive in the sense that on the one hand, it doesn't change the basic point or the basic view of the Biden administration and the Obama administration that DACA is well within the president's legal authority. And for reasons that Shoba just explained. But it's cautious in the sense that as written, it adopts the general requirements of DACA as originally adopted in 2012. And much of the reason it's structured the way it is to make sure that DACA survives any legal tests that may come its way. And these are legal tests that I think it's worth thinking about. They've emerged in two main reference points that I'll just briefly highlight. One of them is Judge Hainan is a federal district court judge in Texas. He issued a decision in this summer, in July of 2021. That's one reference point. Another reference point is the Supreme Court's decision last year invalidating the Trump administration's attempt to rescind DACA. So I think if I get into these decisions a little bit, you'll see what exactly the background of the structure of this regulation, the proposed regulation is. So Judge Hainan, one of the reasons that he issued partially, at least, an injunction against DACA is that he found what I think is worth calling a process defect, that the regulation, the original DACA did not go through what's called notice and comment rulemaking. And that's the process that you're seeing now. In other words, publishing a proposed regulation, taking comments, and finalizing the regulation after assessing all those comments. Now, the Obama administration's position was the notice and comment rulemaking wasn't required. DACA was adopted initially without that process and the reason, the stated justification is that DACA wasn't announcing was announcing a general statement of policy, but not a new substantive rule. And so that's a distinction in administrative law, but it basically meant that according to the Obama administration, you didn't need to go through the publication of a proposed rule as we're seeing now. So this proposed regulation directly corrects this possible defect. I emphasize the word possible because I don't think there's a concession that it really is a defect, but just to be careful, by addressing that problem, we now have notice and comment rulemaking, which is what you see in the publication of a proposed or notice of proposed rulemaking, NPRM, and comment period. And then there are a couple other potential substantive defects here in that the regulation is set up to address. One of them is something that Shoba alluded to or actually addressed, which is there's a lot of confusion that some judges have I think plagued the analyses of some judges on the distinction between lawful status and a lawful presence. And there are hints in some of the decisions on DACA over the last few years that DACA somehow grants lawful status, which is not true. DACA grants what we think of as lawful presence, not lawful status. Now, that may seem like a very lawyerly and very technical distinction, but as Shobha mentioned, it really runs through the history of immigration law. And status, such as getting a green card or path to citizenship, those are things that only Congress can provide. But DACA doesn't try to do that. DACA simply provides a more minimal situation called lawful presence, which is an official temporary tolerance. It's not a durable immigration status. That is the type of status that only Congress can provide. So the regulation, proposed regulation, tries to clarify this and invites comment, but I think it's important that it tries to clarify this point of confusion, which also plagued, I think, some of the deliberations in the US Supreme Court. Okay, now, the other potential substantive defect, I don't agree that, frankly, that these are substantive defects, but I think that the regulation is drafted or proposed in a way that tries to head off any potential problems. And so, the argument that that some judges, like Judge Hainan, have found persuasive is that DACA is illegal because it goes further than what the long history of prosecutorial discretion has allowed and continues to allow. And that's protection against deportation. So this is something that the Supreme Court in 2020, the year 2020, called forbearance. In other words, that we will forbear, we will not arrest, detain, and deport people. That's one part of prosecutorial discretion. And I suppose in some sense it is the start of, or the core of prosecutorial discretion. But DACA goes further by providing not just forbearance, but also eligibility for work authorization. And so the argument would be potentially that by providing both forbearance and other things, other benefits, including eligibility for work authorization, that DACA exceeds what is historically allowed. I'm on record in several places of disagreeing with that, but I do see that this is an argument that has been persuasive to some courts, including to Judge Hainan. So that perception of the defect is based on a 2020 Supreme Court decision in Department of Homeland Security versus Regents of the University of California. Now, that's a decision that where the court did not ultimately address or decide the question whether DACA is lawful or not. The court only addressed the process by which the Trump administration tried to rescind DACA. But what's interesting is this, that the court found that the Trump administration's attempt to rescind DACA was legally defective because it failed to consider several key aspects of DACA. And what the court said was, the Trump administration should have considered, could have considered, and should have considered whether the DACA should be kept as a matter of forbearance, in other words, protection against deportation, while at the same time, this was a possible thing to be considering by the Trump administration, keep forbearance, but not necessarily keep the part of DACA that grants eligibility for work authorization. So there's this hint there that some justices in the court, or perhaps the court majority, might see the granting of work authorization as having a somewhat weaker legal foundation and prosecutorial discretion than the reprieve or protection from deportation. For reasons that Shobha already explained, I think that the history of work authorization actually rebuts that potential argument. But there is this possibility that the federal courts, including the Supreme Court, may ultimately decide that the forbearance part of DACA, the protection against deportation, is within the president's power as a matter of prosecutorial discretion, but that for some reason that the work authorization part of DACA is invalid because it goes beyond the president's power. So this explains, or I think goes a long way toward explaining why why we have the separation of work authorization from the deferred action part of DACA. I'll close with a couple of thoughts on this. I mean, this raises the proposed regulation is structured in a way to foresee the possibility that eligibility for work authorization is invalidated, but that the forbearance part of DACA will survive legal challenge. In other words, there's a so-called severance clause where even if the work authorization part is struck down, that the deferred action part will survive. So separating it out this way raises that possibility. It's also possible that by making work authorization separate, that aspect of DACA is actually on its own on stronger legal footing, because it may end up being seen as more discretionary, not automatic, therefore more within the discretion part of post-control discretions. In other words, you put the regulation into two parts, making more likely that the deferred action part will survive. But I actually think that it makes it more likely that both of them will survive separately as well. Now, another feature of this, which is a consequence worth noting, is that it allows the lowering of the fee for those who only want deferred action and for whatever reasons do not need the work authorization. But I suppose it does raise the possibility that it will be easier to invalidate the work authorization part because you've separated it. And the last thing I'll say is it raises the possibility that some DACA recipients will actually not get work authorization in the exercise of discretion on that part of the rule. So it's a very complicated rule. I'm sure that my explanation has underscored its complexity. But I think that it is very important to understand that this is a cautious and defensive rule. And that's the reason for its formulation as it is. So thank you.
Hiroshi, thank you. I was going to say you were rendering a rule that was complicated and complex, clear, but still underscoring the complexity of it. But I think it's really important as we get further on in understanding the rule. And now let me turn to Dan, who is going to talk more about, so what does this mean for campuses and for students and alumni?
Sure. Hi, everybody, and thanks to Hiroshi and Shoba and Cezanne for explaining their perspectives. And I'm thrilled to see how many people are on this call. I know that after the last few years that many of you are probably tired if you're the person on your campus who writes comments about regulations or policies. I'm sure you're tired after the last couple of years. So let me talk just a little bit about what there is that you might say or do in response to this regulation now that it's been explained to you, or this proposed regulation. And I think that the place to start is really, what is your experience with DACA? DACA's been around since 2012. What have been some of the positives and negatives on your campus? Let's start with the positives. I hope and I assume that you've all had positive experiences with employees, with scholars, with students, now with alums being able to work. Tell those stories. There will be negative comments. There will be anti-immigration forces who are organized to submit comments and talk about the negatives of DACA. So I would say let's get the positive stories out there and explain why. And this will be really helpful, because then by law, the Immigration Service is required to read all of the comments and to supposedly to reflect on them in a final rule. We can pretty much assume that the final rule will be similar to what we see here. I think this is the administration's position. It's a codification. It's a sort of a cementing of DACA, as Hiroshi said, in notice and comment rulemaking. But let's allow the administration to be, or in the USCIS to be able to say, we received a lot of comments from DACA students and from former DACA students and from colleges and universities, and they told stories. And again, say what you think, but also give some specific examples. I think it's also important to, when you're making comments, to have them all be different. It's easy to sign on to a template comment, but The Immigration Service does have a tendency to sort of say, to say just in one line, oh, we got 400 comments that were all verbatim the same, so we're not paying attention. I'm not sure that's fair, because I think each of those 400 commenters believed what they were signing, but to the extent that yours can look different, whether it's the font or the format or the actual verbiage, that would be good. And again, submitting a positive comment is not only an important statement for the federal record and for the strength of this regulation, but also as a statement of what your college believes in. I think it will be. It's important. DACA students, undocumented students, I don't have to tell you, over the last 4 years have faced a particularly high level of uncertainty in their immigration status and their family's immigration status. And an open letter taking the time to do this really means something. Also, I think I don't know whether there's political will to go beyond the current DACA at all, to make some tweaks in this, or major or minor in DACA in the form of this regulation. But I think it may make sense to suggest that also. So in addition to positive comments, positive stories, think about what you've seen on your campus and where the challenges have been. Have you had trouble with work authorization being slow to renew? Have you had trouble with people wanting to travel but not being able to because of issues with advanced parole? And I'll talk about a couple of those in a minute, but think about that and perhaps focus the second part of your comments on specific stories of people who've had challenges with DACA as it's currently constituted, and how this regulation could be tweaked to fix that. And just as a quick historical note, STEM OPT came out as a policy. It was challenged in court, and it went on for many, many years. And the Obama administration basically went back and created a regulation like this, went through the notice and comment process. In the process of that notice and comment rulemaking, STEM OPT ended up being even stronger and more useful than it was before. So I think this is something that could help. And also, if DACA does go through notice and comment rulemaking and then survives judicial challenge, who knows? Perhaps this could even empower the administration to consider some of the other ideas that the Obama administration was considering before all these court challenges, such as DAPA, which was an extension of DACA for parents of US citizens and others. So just quickly, a few issues that you might consider commenting on, again, based on what your campus experience has been. Travel. Right now, unlike any other travel document for any other immigration category, as far as I know, DACA travel is limited to humanitarian, educational, and employment purposes. That sounds like a lot, but there are issues, there are times where people want to travel for very legitimate purposes and can't get parole. So I think perhaps expanding the level of the types of reasons, the grounds on which one can get travel permission. Work card delays. This is a big one. It is so incredibly frustrating that work cards are slow, and that a DACA work card, unlike some other work cards, is not automatically extended by filing the extension. So that is something you could also ask for. And if you have examples of alums or employees or students who had to stop working for a while because they filed a work card extension and it just took a long time to get the new card, and it came after the old card had expired, talk about that and suggest that. Fee waivers. Fee waivers are just a perennial challenge in the Immigration Service. I find that there's just a tremendous amount of inconsistency in filing fee waivers, and also it slows everything down to file a fee waiver. So some kind of organized policy around fee waivers. Part of a DACA application involves explaining why the student needs a work card. If a student is on a full scholarship, if a student, I think I think a fee waiver should make sense, and maybe there can be some kind of codification of that. And then in terms of a big picture change to DACA, I have no idea whether this is possible, but I personally would say let's ask. Right now, DACA involves having been here since 2007. That age could be moved up. The Obama administration had considered moving that age up. And again, specific examples matter. The most common example we see are siblings. It is really tough for not necessarily siblings, but what we see is people who came here more recently. So often it's cousins, it's other family members, it's friends who see their friends or family members being able to get DACA and being able to work after college, and these people not being able to. So you can take a look at that and see if you have examples. And again, if you've been to some of these briefings before, I always end up saying DACA is a great program. It's so much better than it was before DACA, but it is still temporary, and Hiroshi and Shova explained that. So please, in the context of all this, when you're interacting with people on DACA, do encourage them to contact a local legal service agency, try to see if they have any longer term options. Many of them might be able to look for longer term options. And our goal, as much as I would like to fortify DACA, our goal is to take every DACA student eventually and move them one by one through good lawyering into a longer term status. And with that, I'll turn it over to Miriam and Jose.
Thank you so much, Dan. And, it was great to hear from you and all those issues that you're raising. And as we know, an increasing number of students are actually coming to campus who are not eligible for DACA, as you're saying, because they arrived after June 15, 2007, or for other reasons. Now let me turn to my colleague, Jose, who's going to actually be able to provide you with a guide that includes many of issues that Dan brought up and others. Jose, over to you.
Good afternoon, folks. Thanks so much for joining today. I'm going to be talking about two quick buckets. The first is the role of the DACA FPRM and campuses, and the second will be talking a little bit about how reconciliation and the current state of play fits in. So as kind of previewed before by other speakers, this entire comment process involves federal agencies requesting comments and feedback, which ultimately are going to shape what the final rule and regulation will look like. In this case, they are reaching out to stakeholders such as institutions of higher ed, and federal agencies are actually required by law to respond to each of your comments. What happens at the end of this process is they'll actually release a spreadsheet that will show all the comments they received, and they will go line by line and explain why they adopted certain recommendations and why they did not adopt other recommendations. So this is just a tremendous opportunity where higher ed campus feedback is acknowledged and reviewed closely by administrative officials. DACA also has this incredibly important impact on higher ed campuses, and it's really important for USCIS and DHS to obtain this perspective, obtain this information, and receive that unique feedback stemming from higher ed campus and DACA's role on campus. So everything from contributions by DACA recipients on campuses to the curriculum, to extracurriculars, to diversity of the campus as a whole, and even as alumni. Now, DHS is enshrining the DACA memo and subsequent guidance into regulation. It is said that it is likely not going to change some of the broad eligibility grounds in the memo, such as the cutoff date and the date by which someone must have been in the country. That's not to say that campuses can't weigh in on those things, particularly if you want to speak on behalf of the many DACA potentially eligible folks that were left off, because the memo's criteria has not been improved or adapted since 2012. At the same time, there is a wide variety of guidance and policy information that is being implemented through the regulation, where USCIS has very clearly said, listen, this is how we've been applying the program for the last 8 years. None of this was in the original memo, and now we want feedback to see if you all have feedback in terms of how to best shape this guidance. So to really facilitate and help you all comment, we created this template guide for higher ed institutions on how to comment, which provides direct links in terms of how to submit your comment, template language, and also advice on how really you can customize comments using state-based data, and advice on which portions of the regulation make sense for higher ed to weigh in on, in addition to the great points that Dan and other speakers have raised. This includes the separation of work permits from deferred action, the issue of dreamers who are documented and are currently not eligible for DACA but could be, various adjudication and processing recommendations, and certain eligibility grounds that were essentially shaped through the implementation of the guidance. So we definitely encourage you all to comment, mostly because it's really important that DHS receive lots of unique comments. And that's why we're gravitating towards providing this template guide for you all, so you all can customize it and send it on your own letterhead. And DHS is swamped with all these different recommendations and comments coming from a wide variety of stakeholders, instead of just like a single sign-on letter that they can read, respond to, and then move on to the next one. So that really is the strategy behind getting as many institutions and stakeholders to weigh in a unique and value-added way. Now, at the same time that this is happening, we are still pushing for permanent relief for dreamers because, as other speakers mentioned, while this regulation's goal is to prevent the litigation from striking DACA down, we don't know how long DACA has to live. And the ultimate solution really is going to be providing permanent relief. And we're doing that through the ongoing reconciliation battle. So for you, those of you that are not familiar, reconciliation is basically this process that allows legislation to be passed by Congress that allows it to bypass the filibuster in the Senate. And essentially, Congress can do this once a year, but all the policies they're in must not be incidental to the budget, e.g., their fiscal impact must be significant compared to their actual policy impact. And that'll be very important in a little bit. Now, the current state of play on this is that Democrats are trying to incorporate immigration-related provisions in the FY 2022 budget reconciliation bill. If you've heard conversations about the $3.5 trillion infrastructure bill, that's what I'm talking about. So right now, Democrats are hoping to have an aspirational deadline of passing this bill by October 31st, 2021. Right now, there's a big negotiation happening around what the top line numbers are going to be, e.g., how big is this package going to be? And we think it's going to be somewhere between the 1.5 trillion that Senator Manchin has floated in the past and the 3.5 trillion that Democrats and the Biden administration are looking for. While that fight happens, there's another concurrent fight, and that is an immigration fight. Essentially, and you may have seen in the news, Democrats have pitched a wide variety of immigration programs in an effort to get those programs into the bill. The issue is that the Senate parliamentarian offers advice regarding whether or not those programs will be compliant with the rules in terms of what's appropriate for reconciliation and what's not. So previously, Democrats proposed a legalization provision that would establish a roadmap to citizenship to about 8 million undocumented folks. The parliamentarian said no to that. In response to that, Democrats introduced a second provision that would update the registry, which is this fancy term of art that essentially says if an undocumented immigrant has been in the country for X years, they're able to get a green card. The parliamentarian said no to that. Democrats are now on to their option C, which is this proposed parole program that would allow folks to apply for parole, which provides work permits and the ability to apply for advanced parole and leave and re-enter the country. It doesn't offer an independent path to citizenship, but those that have an existing path via someone that could sponsor them would be able to potentially get a green card, but that's a very small minority. The benefit there is that this would be an 8-year renewable grant for about dreamers, TPS holders, farm workers, that would allow them to essentially live in the country without fear and really focus on being able to support themselves and their families. So right now, Democrats have not pitched that option yet. They're waiting on a CBO score because they can't pitch these programs to the parliamentarian until they have that CBO score. So we think that they're going to pitch that program to the parliamentarian sometime next week or the week after, depending on what the parliamentarian says. If the parliamentarian says yes, it's likely that that will be the program that gets included in reconciliation. And if the reconciliation bill passes, then great, we have this wonderful new program, which we will definitely be doing a briefing about. If not, if the parliamentarian says no, there may be a situation where folks begin to be more outspoken in terms of calls to have Vice President Harris as the presiding officer of the Senate to essentially not take the parliamentarian's advice, which would require 60 Republican votes to overrule. That is a politically less attractive option to the White House, but that is much more likely and much less controversial than firing the parliamentarian or trying to get 51 votes to explicitly overrule the parliamentarian. We have not taken a position on that. Right now, we are just focused on getting permanent relief for folks, whether that's parole, whether that's through other mechanisms. We're still trying currently. So you will see some big developments over the next couple of weeks. So keep an eye out for our member updates and subsequent briefings, because by the end of October, we're going to have more information regarding this potentially life-changing program for millions of people. I'll turn it over back to Miriam.
Thank you so much, Jose. And I think also what you're hearing now is that there's a lot of need for campuses, for institutions and individuals to submit comments to this rule. And I'd like to ask all of you on the call to just ask one other colleague at another institution to also be considering submitting a comment. But let's start and let's ask all the speakers to come on camera and have a conversation. And I'd like to start actually with Suzanne. Dan was making a very compelling case about why it's important for campuses to submit comments. From your perspective, if you were going to talk to an institutional leader or someone at Miami-Dade to submit a comment, what would you say?
Thank you, Miriam. One thing that I would say is, especially, we as ourselves as DACA recipients and undocumented youth, we can speak up for ourselves, but it's so essential to have people who are in a higher position to really see and show the impact of what these students are doing or what we're trying to pursue. There's so many of us that where our education is important, and without DACA, we are, highly unlikely to be able to complete some of our goals. And the people who are in a better position to kind of speak and show forth what these students are trying to do, what they're trying to achieve, and all the possibilities. Somebody who's in a higher position, they have a little bit more of a higher stand-in and reaching out to more of the community. So it's just so important to show how important the students can be and what they could possibly achieve if they're given the opportunity.
That's great, because I think it's really underscoring that institutional leaders need to advocate alongside of students. It's not, students have their own agency, institutional leaders have to also take accountability. Before moving on, is anyone else want to kind of comment from your perspective why it's particularly important for institutions to comment, or a particular issue you'd like to see institutions commenting on? Okay, well then let me talk about one issue that I know we've discussed in the Legal Advisory Council of the President's Alliance, and the President's Alliance does plan to address this in our own comment, and Jose has also mentioned it's part of our guide to institutions. And this is a question from Candy Marshall, president of the Dream.us. If there's confidence that this approach is indeed legally well-grounded, it would seem that the administration could be less cautious and extend the arrival date to be 5 years before the final rule. Should we be advocating for this? I mean, talking about how the rule is really grounded and trying to be both, cautious, but at the same time be clear and really take the rule. Shoba or Hiroshi, would you like to start?
I can get started. I think that every commentator should be paying attention to changes or proposals they might have for improving the rule. And some of those comments are going to essentially take the rule further than it is. And I think and Hiroshi alluded to this, there are also going to be negative comments, right? So I think there's both sort of sound policy and strategy in identifying the pieces in the proposed rule that you believe don't go far enough, and identifying how to change it. There's always a balance, right? I mean, one of the reasons why we have this proposed rule is that it is partially in response to the direction that the litigation is going in. So sweeping proposals may not have the same strength in the end as tweaks and changes to date of entry or when you are in unlawful status, for example.
Thank you. Hiroshi?
Yeah, I mean, I'll just add a couple of points to that. I mean, one is that, you know, I believe that the rule is very cautious and very focused on defending against legal challenges. I was one of those who believed that the original DACA was very well within the president's authority. I'm certainly convinced that this regulation is well within the president's authority, but that doesn't mean that every federal judge who may have this case land in his or her chambers is going to feel the same way. So in that sense, it reflects a certain cautiousness and a certain anticipation. That said, I don't think that advancing the cutoff dates from 2007 forward and from 2012 forward has any effect on the legality of DACA. And for that reason, in fact, I would say that advancing the dates is very much in keeping both with the idea of exercising prosecutorial discretion, but also consistent with President Biden's statements that he is in favor of preserving and fortifying DACA. And to me, that includes the idea that DACA is essentially enacted as it is, but with updates for the passage of time, obviously, in the time since 2012. If the number of people who would be made eligible for DACA by advancing the date from 2012 closer to the present, if it were to be a huge number of people, then you might run into some of the atmospherics that some courts have said, well, that's just too big a number. But I don't think we're talking about that. I think we're talking about a zone of people who are a number of people who are very much hurt by not advancing the cutoff dates, but not so great a number that it's going to be setting off, raising red flags from a legal basis. But I'm not in a good position. Maybe none of us are, of really predicting what's going to happen. And so, in that sense, the cautious and defensive anticipatory approach of the administration is what you see here.
Yeah, and maybe just
let me just make one other. Can I just make one other point? And that I think it's important that if we're in a situation where this version of DACA goes in without advanced dates, in other words, if the administration rejects any proposals to advance the date, I think it's important for some institutions, depending on individual circumstances, to make the record and make the case that so many people are affected and the reason why it's worth advancing, because that would lay the foundation for another version of DACA in the future.
No, I think that I completely agree. And I was just going to say that, thinking back again to the example of STEM OPT, which was created without notice and comment rulemaking, again, many of us thought appropriately. And then during the course of notice and comment rulemaking, it really forced universities to kind of think about what was working and what wasn't. I mean, we now have had DACA since 2012. We know we know what the weaknesses are. We know what the holes are. And in the case of STEM OPT, the final regulation did actually expand STEM OPT over what it was in the original policy.
That's a great example, Dan, because if I remember correctly, there were over 50,000 comments during that period, and all with these stories about how important it could be and would be. And we know for a fact from talking to so many campuses that there's so many students now, undocumented students now on campuses that are not eligible for DACA. We know from our own research that less than a majority of undocumented students on campus are eligible for DACA for a variety of reasons. So yes, the kind of highlighting that is so I think this is the time to do it. You brought up the Texas case. And one of the questions that we also had was, how does this proposed rulemaking timeline intersect with the Texas challenge and the timeline of trying to appeal the Texas decision, which does not allow for new applicants to be processed? Is this going to impact when we may see DHS processing new applicants again? And I think I believe that the administration recently asked for that appeals process to be put on hold during the rulemaking. I'm not quite sure who could be best in terms of talking about this, but Hiroshi, maybe starting with you again about this. Yeah.
Well, there are different ways. I mean, that appeal's been formally filed at least, and so there's that possibility. But then, of course, we have this notice of proposed rulemaking going forward. I honestly am not sure what the procedural options are for this case to essentially continue, for example, in the district court for more consideration of new facts, namely the filing of this proposed rule. I mean, of course, what the Biden administration is hoping for is that the notice of proposed rulemaking changes or pulls the rug out from under the original July 2021 decision, as this is the facts have really changed. We're not really even talking about a lack of notice and comment rulemaking. We have it. And it's not just the correction of the process. It's not just the correction of the process defect or the alleged process defect of not having rulemaking. It's also the fact that the notice of proposed rulemaking addresses some of the potential concerns with the potential concern that somehow the rulemaking is stepping on the toes of Congress. It actually has a lot of commentaries designed to ward that off. I don't know if it'll be persuasive or not, but I'm honestly not sure how it's going to, whether it's going to be an amendment to that litigation or that litigation itself in the lower court is held in abeyance. And I'll note that when the Supreme Court granted review in DHS versus Regents of the University of California, the same judge in Texas held that case in abeyance at the district court level. So perhaps that's hints at what might be the solution here, or the outcome here. But that's a long way of saying I'm not sure.
Anyone else want to add, or I think that's a good answer, the knowing when to say I'm not sure, but Shobha.
Yeah, I mean, I don't feel qualified to answer that question precisely, but I will share that, both the Texas ruling and this comment, documents the fact that the judge did remand this case to the Department of Homeland Security. And, even prior to the decision, there was an indication by the department that it was going to engage in notice and comment rulemaking. So I think we're seeing two things happening simultaneously, right? Where our rule has been promulgated, there's a 60-day period. The administration has also appealed the district court decision. Who's going to be on first and how is one going to affect the other is what remains to be seen.
Wonderful. And, we got a question also about, I understand the need for personalized comments, individualized comments by campus, but is there some model language that campuses can use for the complex immigration legal arguments? And we noted that, in fact, in our guide, there is some language to address the legal arguments that have been raised here. And also the President's Alliance will endeavor to get to all of our members, our comment before the 60-day period. So if we kind of are partnering with you, our campuses and others, to get the stories and what's specific and important and compelling on your campuses, you can also both have what's in the guide, but also take whatever you'd like from our comment before submitting. And there'll be also other resources for you. With that, I think if we can I just want to thank you so much. This went so quickly. There's so many questions. We're going to continue to be focused on that. We encourage anyone who has additional questions to reach out to us. If we can put up the resource slide again, thanking our speakers. These slides are in the Google folder. We sent to all registrants. There's also a survey that we always do after our briefings. Please feel free to fill that out, because what you say is what we listen to, and we try to strive to be better and better with all of our briefings. Our speakers were excellent. Thank you so much, Suzanne, Shova, Hiroshi, Dan, and Jose. And I just want to thank everybody for all the work they're doing. I know this is a difficult semester with so much happening, but as Dan said, we're so grateful for everyone who's on. Thank you so much. Bye-bye.